very good evening to everyone who's attending this. I'll be discussing this case, Philips Lighting Holding and Signify Holding. Just a brief clarification before that is that Philips and Signify are basically the same entity, and there's only been a corporate name change before the second suit was filed. To give a brief idea of the facts is that the plaintiff, which is Philips, they filed two suits under the Order 39, Rules 1 and 2 of the CPC, claiming rights in the design of its T-shaped LED bulb. Referring to the products of the defendants, the plaintiffs have submitted that the same are infringing copies of its registered design and are ought to be injuncted. Here you can take a look at the comparisons between the two products, the left side being that of the plaintiffs, the right being that of the defendants. Moving on, the arguments that have been submitted by both the parties here, firstly by the plaintiffs, is that the plaintiff has claimed novelty in the above designs, in the unique T-shape and the plug-and-play format. Secondly, the plaintiff is the original equipment manufacturer, in short, the OEM, for several lighting companies in India, which procure the plaintiff's T-bulbs and sell the products under their own brand name, subject to the payment of a license fee. Thirdly, referring to the products of the defendants in both the suits, the plaintiff submits that the same are infringing copies of the plaintiff's registered design, and they are ought to be injuncted. To support this, they've produced photographs as well as products before the court. The plaintiff further submits that the defendants are guilty of passing off their impugned products as that of the plaintiffs on accounts of a deceptively similar look, feel, and trade dress of both the products. The defendants in turn have argued that the plaintiff has claimed passing off in a design. The design registration is liable to be cancelled in such a scenario, because by the very definition, a design does not include a trademark. And the moment the plaintiff has claimed a right in a design as a trademark, the same is liable to be cancelled. The other ground on which the defendants have claimed that the plaintiff's registrations are to be cancelled is under Section 19(1)(a) and 19(1)(b) of the Designs Act. Section 19 of the Designs Act speaks about the grounds of cancellation of a design application. They've submitted that the designs have been previously registered in India. They've been previously published as well in India and in other countries. In this regard, they have submitted two documents of predated Indian registered designs in favor of an individual, and also 5 other Chinese and US patents on the variation of this T-lamp design was submitted. The plaintiff, they further argue that the plaintiff is not entitled to design protection as it has claimed functional aspects of the designs. In a rejoinder, the plaintiff has just added one more argument, saying that the defendants have not produced the products bearing the designs or the patents which they have provided prior, for which they have provided the prior registration details. They've also pointed out that for challenging the registration of the plaintiff, it was incumbent upon the defendants to show prior publication, which necessarily would mean a prior product in the market or the industry bearing a similar design. Now, the court have listed out the following findings. They've referred to the section 2A, 2D, subsection G, 4, 6, 19, and 22, by which they've provided a definition of design. I mean, they have reiterated the definition of design, pointing out that it refers only to the features of shape, configuration, pattern, ornaments, or composition of lines and colors applied to any article in 2D or 3D, which in the finished or both, which in the finished article will appeal to and should be judged solely by the eye. The design should be new and original, and if the design has been previously registered in India or has been published in India or in any other country prior to the date of its registration, such registration itself is to be cancelled and can also be used as a defense in a suit alleging piracy of registered design. On novelty, the court has pointed out that the matter of novelty is to be judged. So the ultimate test should be the test of the eye and the normal ocular impression. In order to know its newness or originality, it is necessary that a design identical with or even materially similar to a relevant design should not have been previously published or registered. Taking into account the nature of the article involved, the change introduced should be substantial. It is not necessary to justify registration that the whole of the design should be new. The newness may be confined to only a part of it, but that part must be a significant one, and it should be potent enough to impart to the whole design a distinct identity. Based on the prior registrations as submitted by the defendants, the court held that the plaintiff's design is neither new nor original as understood from the Act. The next finding is the test of sameness while judging piracy of a registered design. The sameness of the feature does not necessarily mean that the two designs must be identical on all points, but they have to be substantially the same. The substantial points of differences are to be found out, not on purely subjective or aesthetic basis, but must be objective in its essential features and easily identifiable on visual examination. Relating to this particular case and on the basis of this test, the court has held that the design of the plaintiff and the defendant can be easily said to be similar, if not identical. The fourth finding is the test to determine whether a design is merely functional. It is, the court has said that the test as to determine whether the design is merely functional or not is by asking a question whether there is no other shape or configuration available in which the product can discharge the desired function. If no, the registered design is entitled to protection. The onus of proving this, again, is always on the defendants. Relating to this particular case, the plaintiff's claim of functional aspects of design does not disentitle them from protection because it could not be established by the defendants that the shape and design adopted by the plaintiff is the only shape or design by which the desired functionality could be achieved. The fifth finding is that the mere trade variants of existing products cannot be registered. A design identical with or even materially similar to a relevant design should not have been published or registered previously. A slight trivial variation from the pre-existing design shall disqualify the relevant design for registration. The change introduced should be substantial. Mere trade variants of what is already in existence or what is common to the trade is not capable of being registered. Now, applying this test to the fact of this present case, it prima facie appears that the design of the plaintiff is merely a trade variant of an already existing registered design as cited by the defendant and was not capable of being registered. Lastly, the court has provided clarity on the term publication. They have said that the existence of a design in the public record or office of the Register of Design may or may not amount to prior publication, depending upon the facts of each case. It would be a prior publication only if the registered design is made public and has necessary clarity as applied to a specific article, capable of being judged by visual appearance. Again, relating to this present case, the court has said that the prior registered designs were clear enough and depicted the end product with the said design. Thus, the defendants had been able to show that the design of the plaintiff was not new, but a variant of an already existing design. To conclude, the order that the court has passed is that the plaintiff's claim of ad interim injunction was to be rejected, and the defendants in both the suits have been directed to file accounts of their sales made under this impugned designs on affidavits on a half-yearly basis until the pendency of the suits. That's about it from my end. Thank you.